This is the part two of the discussion on Bill of Rights, and today we will be reviewing the concept of search. The constitutional guarantee does not prohibit all forms of search and seizures. It is only directed against those which are unreasonable, as stated in Veridiano versus People, a 2017 case of Leonin. To be reasonable, there must be 1. A valid warrant, or 2. A valid warrantless arrest. The right to be secure is available to aliens and juridical persons, as stated in Stonehill versus Jokno. The right to be secure is a personal right. It may be invoked only by the person entitled to it. Further, it can only be waived by him. The protection against unreasonable searches and seizures cannot be extended to acts committed by private individuals without intervention of police officers, as stated in People versus Marty. The examples is search conducted by security guards of private establishments. However, search by Barangay Tanod is covered because Section 2 states that he is an agent of person in authority. As a rule, only the judge has the power to issue a warrant. As an exemption, the Bureau of Immigration may issue warrants to carry out a final finding of a violation, such as a legal order of deportation issued by the Commissioner of Immigration in pursuance of a valid legislation. Hence, Section 2 does not extend to deportation proceedings. What are the requisites of a valid warrant? So, the requisites of a valid warrant, the acronym is PPOP. First, it's a probable cause. So, there should be a probable cause. And number 2, it has to be determined personally by a judge after examination, under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So, again, that's probable cause, personally examined by the judge after examination, oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Probable cause is merely probability and not absolute certainty. Syempre, kapag absolute certainty na yun, di makukulong na siya, convicted na siya. So, it's just a probable cause. Search warrant, there should be facts and circumstances that would lead a reasonably prudent man to believe that an offense has been committed and that the objects sought in connection with that offense are in the place to be searched. Warrant of arrest, these are facts and circumstances. There should be a facts and circumstances that would lead a reasonably prudent man to believe that an offense has been committed by the person sought to be arrested. So again, in warrant of arrest, there should be facts and circumstances that would lead a reasonably prudent man to believe that an offense has been committed by the person sought to be arrested. While in search warrant, there should be facts and circumstances that would lead a reasonably prudent man to believe that an offense has been committed and the objects sought in connection with that offense are in the place to be searched. For search warrant, there should be personal examination under oath or affirmation, must be in writing and in the form of searching questions and answers. The oath must be made in such a manner that perjury could be charged and that the affiant could be held liable for damages caused. The search questions and answers must be probing and exhaustive and not merely routinary or pro forma. Further, the complainant and or witnesses must be examined on facts personally known to them. Lastly, the judge must attach to the record the sworn statements and the affidavits submitted. For warrant of arrest, personal evaluation, the judge need not personally examine the complainant and the witnesses he may produce. It is sufficient if he personally evaluates the report and the supporting documents submitted by the prosecutor regarding the existence of a probable cause. If on the basis thereof, the judge finds no probable cause, he may disregard the report and require the submission of supporting affidavits to aid him in arriving in the concluding the existence of probable cause. For warrant of arrest, probable cause during preliminary investigation could be established with hearsay evidence. Hence, the judge may personally evaluate a fiscal's report containing hearsay evidence. To recall, in search warrant, the complainant witnesses must be examined on facts personally known to them. Particularity. For search warrant, it was held that the Constitution does not require the warrant to name the person who occupies the described premises. The test of particularity for the place to be searched is as follows: whether the description is sufficient and descriptive enough to prevent a search of other premises located within the surrounding area or community. The test of particularity of things to be seized are as follows. Direct relation. When the description described therein is as specific as the circumstances will ordinarily allow. When the description expresses conclusion of fact and not of law, by which the warrant officer may be guided in making the searches and seizures. When the things described are limited to those which bear direct relation to the offense for which the warrant is being issued. For warrant of arrest, it is said to particularly describe the person to be seized if it contains some description which will enable the officer to identify the accused. For both, the place must be particularly described. What is a general warrant? General warrant is defined as a warrant that is not particular as to the place to be searched or the person or the property to be seized. Hence, it gives the officer the discretion over which place to search and the persons or properties to seize. What is a scattershot warrant? A scattershot warrant is a search warrant issued for more than one specific offense. It also violates the constitutional requirement of particularity. The search warrant is merely for dangerous drugs. However, the police officers also found a firearm in the place searched. Is the firearm admissible as evidence? No, the search warrant is limited to those things particularly described. What happens to the firearm? It would merely be confiscated for being a contraband. No presumptions of regularity are to be invoked in aid of the process when an officer undertakes to justify under it. A search warrant is severable. Lack of particularity with certain things does not render the others void. The judge issued warrant of arrest when the prosecution only submitted the resolution and affidavits of the complainant. The prosecutor did not attach copies of the affidavit of witnesses and the counter affidavit of the respondent. Then, the judge committed grave abuse of discretion. Okabe versus Judge Gutierrez. Next topic is warrantless searches and seizures. Consented searches. There must be clear and convincing evidence of waiver, otherwise there is no waiver. The police officer must communicate this clearly and in a language known to the person who is about to waive his or her constitutional rights. There must be an assurance given to the police officer that the accused fully understands his or her rights. It is not sufficient that the police officer introduce himself or be known as a police officer. People versus Cogaed. To determine if there is consent, the totality of the circumstances must be determined, such as the age of the defendant, whether the defendant was in a public or a secluded location, whether the defendant objected to the search or passively looked on, the education and intelligence of the defendant, the presence of intimidating coercive police procedures, and others. In Verijan versus People 2017, mere passive conformity or silence to the warrantless search is only an implied acquiescence, which amounts to no consent at all. The presence of intimidating coercive environment negates the claim that petitioner consented to the warrantless search. In People versus Cogaed 2014, Leonen stated that Cogaed's silence or lack of aggressive objection was a natural reaction to a coercive environment brought about by the police officer's excessive intrusion into his private space. The prosecution and the police carry the burden of showing that the waiver of a constitutional right is one which is knowing, intelligent, and freedom from any coercion. In all cases, such waivers are not to be presumed. And the bar lean towards no consent, since there's always a presence of intimidating or coercive environment brought about by the police. Next topic, search incident to lawful arrest. Rule 126, Section 13 of the Rules of Court. A person lawfully arrested may be searched or dangerous weapons or anything, which may have been used or constitute proof in the commission of an offense without a search warrant. The cardinal rule on searches incidental to lawful arrest is that there first be a lawful arrest before a search can be made. Vaporoso versus People, in the matter of petition for writ of amparo of Vivan A. Sanchez. In other words, a valid arrest must precede the search. The process cannot be reversed. The search may be made only within the permissible area of search or the place within the immediate control of the person being arrested. How to determine if there is a lawful arrest? We check if there is a warrant of arrest, an in flagrante delicto arrest, or a hot pursuit. If none is present, the search incidental to the arrest is invalid because the arrest was unlawful. What if the search happens first before the arrest was made? The rule on search incidental to lawful arrest shall not apply. For the search to become valid, a peace officer must show that another exception, such as stop and frisk, was present. The phrase "within the area of his immediate control" means the area from within he might gain possession of a weapon or destructible evidence. A gun on a table or in a drawer in front of one who is arrested can be as dangerous to the arresting officer as one concealed in the clothing of the person arrested. Such warrantless search obviously cannot be made in a place other than the place of arrest. In Espana versus CA, where the accused was outside the apartment unit and in the act of delivering to the poacher buyer the bag of shabu, and the apartment unit was not even his residence but that of his girlfriend, the inside of the apartment unit was no longer a permissible area of search, as it could not be said to be within his reach and immediate control. The warrantless search therein was therefore unlawful. Stop and frisk. When there is a genuine reason to stop and frisk in the light of the police officer's experience and surrounding conditions to warrant a belief that the person detained is committing a crime, a mere suspicion or a hunch will not validate a stop and frisk. Malacat versus Court of Appeals. For a valid stop and frisk search, this court instructed in Manibag versus People that the arresting officer should have personally observed at least two or more suspicious circumstances. A reasonable inference must be deducted from the totality of circumstances to justify further investigation by the arresting officer. In the matter of petition for writ of amparo of Vivan A. Sanchez, 2019 Leonen, without two or more suspicious circumstances, the search was not based on a genuine reason. Stop and frisk only extends to bodily searches or limited protective search of outer clothing for weapons. Hence, the bag carried by the person searched is not included. Search occurs before the arrest. The application of stop and frisk to some cases. In People versus Cogaed 2016, the police officers received information that a certain Marvin Buya would be transporting marijuana. A passenger jeepney passed through the checkpoint set up by the police officers. The driver then disembarked and signaled that two male passengers were carrying marijuana. The police officers approached the two men who were identified as Victor Cogaed and Santiago Dayao and inquired about the contents of their bags. Upon further investigation, the police officers discovered 3 bricks of marijuana in Cogaed's bag. In holding that the stop and frisk search was invalid, this court reasoned that there was not a single suspicious circumstance that gave the police officers genuine reason to stop the two men and search their belongings. Cogaed did not exhibit any overt act indicating that he was in possession of marijuana. In Veridiano versus People 2017, Leonen Veridiano was a mere a passenger in the jeepney who did not exhibit any act that would give police officers reasonable suspicion to believe that he had drugs in his possession. Reasonable persons will act in a nervous manner in any checkpoint. There was no evidence to show that the police had basis for personal knowledge that would reasonably allow them to infer anything suspicious. Further, this cannot be considered as a valid search in checkpoints because in checkpoints, only visual search is allowed. Lastly, this cannot be considered as an extensive search of moving vehicle because there is no probable cause that the passengers committed a crime. Visual search at checkpoints. In Valmonte versus De Villa, the court held that the inherent right of the state to protect its existence and promote public welfare and an individual's right against a warrantless search which is however reasonably conducted, the former should prevail. In Valmonte versus De Villa, this court clarified that for as long as the vehicle is neither searched nor its occupant subjected to a body search and the inspection of the vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable searches. Thus, a search when an officer merely draws aside the curtain of a vacant vehicle which is parked on the public fairgrounds or simply looks into a vehicle or flashes a light therein is not unreasonable. The warrantless search of motor vehicles at checkpoints should be limited to a visual search. Its occupant should not be subjected to a body search. Extensive searches of moving vehicles. Stop and search. The extent of routine inspections must be limited to a visual search. Routine inspection should not give law enforcers carte blanche to perform warrantless searches. However, an extensive search may be conducted on a vehicle at a checkpoint when law enforcers have probable cause to believe that the vehicle's passengers committed a crime or when the vehicle contains instruments of an offense. Law enforcers cannot act solely on the basis of confidential or tipped information. A tip is still hearsay no matter how reliable it may be. It is not sufficient to constitute probable cause in the absence of any other circumstances that will arouse suspicion. In Veridiano versus People, the extensive search conducted by the police officers exceeded the allowable limits of warrantless searches. They had no probable cause to believe that the accused violated any law except for the tip they received. They did not observe any peculiar activity from the accused that may either arouse their suspicion or verify the tip. Moreover, the search was flawed at its inception. The checkpoint was set up to target the arrest of the accused. The visual search and extensive search and moving vehicle is different from stop and frisk. So in visual search, there is no probable cause just to enforce public order, so we do visual search. In stop and search, there is probable cause that the passengers committed an offense, so there is an extensive search. In a stop and search, extensive search in moving vehicle, there is probable cause that the passengers committed an offense, and probable cause is defined as facts and circumstances that a reasonable, prudent man would believe that a crime has been committed by the person sought to be arrested. In stop and frisk, there is genuine reason to warrant a belief that the person is committing a crime. The commission of the offense need not be obvious to the ordinary man, but a seasoned police officer. In a stop and search, the search may be extended within the immediate control of the person. In a stop and frisk, the search only extends to bodily searches or limited protective search of the outer clothing for weapons. In a stop and search and extensive search in moving vehicle, there must be a lawful arrest first before there is a search. While in a stop and frisk, there must be a search first before there is an arrest. Number 8, custom searches. There are reasonable searches because of heightened security in De La Cruz versus People. The search conducted on the accused was considered valid because it was done in accordance with routine security measures in ports. However, the rule is not available in dwelling places. The tariff and custom codes does not require said warrant in the instant case. The code authorizes persons having police authority under Section 2203 of the Tariff and Customs Code to enter, pass through or search any land, enclosure, warehouse, store, or building not being a dwelling house, and also to inspect, search, and examine any vessel or aircraft and any trunk, package, box, or envelope, or any person on board. Or stop and search and examine any vehicle, beast, or person suspected of holding or conveying any dutiable or prohibited article introduced into the Philippines contrary to law without mentioning the need of a search warrant in said cases. But in the search of a dwelling house, the code provides that the said dwelling house may be entered and searched only upon warrant issued by a judge or justice of the peace. Port authorities. Routine bag inspections conducted by port authorities, although done without search warrants, are not unreasonable searches per se. Constitutional provisions protecting privacy should not be so literally understood as to deny reasonable safeguards to ensure the safety of the traveling public. Airport searches. RA 6235. Section 9 provides every ticket issued to a passenger by the airline or air carrier concerned shall contain, among others, the following condition printed thereon. Holder hereof and his hand-carried luggage are subject to search for and seizure of prohibited materials or substances. Holder refusing to be searched shall not be allowed to board the aircraft, which shall constitute a part of the contract between the passenger and the air carrier. Conduct of aerial target to zoning and saturation drives in the exercise of military powers of the President. Inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. Search by DOLE to enforce label provisions. Plain view doctrine. The requisites of plain view doctrine, the executing law enforcement officer has a prior justification for an initial intrusion or otherwise properly in a position from which he can view a particular order. Prior justification for initial intrusion. So that's the first requisite. The second is the inadvertent discovery. The officer must discover incriminating evidence inadvertently. The next is that it must be immediately apparent evidence of the crime. It must be immediately apparent to the police that the items they observe may be evidence of a crime, contraband, or otherwise subject to seizure, and that there is no need for a further search. The plain view justified the seizure of evidence without further search. Illustration. Search warrant is for more than one offense. While implementing the warrant, the police officer saw in plain view a shabu in the place search. Is the shabu admissible in evidence? No, because there was no prior justification for initial intrusion on the part of the police officer. Warrantless arrest and detention. Note, the facts must clearly show for an in flagrante delicto arrest that there is an overt act. If it is not clear, arrest is not valid. For hot pursuit, it is probable cause based on personal knowledge of the facts and circumstances. If it is not clear, arrest is not valid. Since there was no valid warrantless search, the warrantless search was also illegal. Unlicensed 22 caliber pistol is inadmissible in evidence. An in flagrante delicto, when in the presence the person to be arrested has committed, is actually committing or is attempting to commit an offense. Hot pursuit, when an offense has just been committed and he has probable reason to believe based on personal knowledge of facts or circumstances that the person be arrested has committed it. And escapee, when the person to be arrested is a prisoner who has escaped from a penal establishment or while being transferred from one confinement to another. Waiver. When the right is waived by the person arrested, the failure to raise the illegality of arrest before arraignment. Continuing offense. Membership in organizations like the NPA and kidnapping are continuing offenses, so a person guilty thereof can be arrested anytime under the in flagrante principle. Bondsmen. Bondsmen may arrest the accused. Attempt to depart. The person released on bail attempts to depart the Philippines without permission of the court. In flagrante delicto arrest, two elements must concur. The person to be arrested must execute an overt act indicating that he is actually attempting to commit a crime, and such overt act is done in the presence or within the purview of the arresting officer. Presence covers all senses: smell, sight, and hearing. Application of in flagrante delicto to actual cases. The accused in People versus Cogae, the accused did not exhibit an overt act within the view of the police officer, suggesting that he was in illegal possession of drugs at the time he was apprehended.